Hi everyone, my name is Kyla Robert, and I will be reflecting on consent and a little bit of negligence with respect to the case I have chosen. I have decided to take this adjusted approach and reflect on legal dimensions I came across in the news. The case I will be examining is currently still ongoing. This is a case about a guy, Jay Boyle, from Pickering, Ontario, who disappeared 19 years ago and his body was never found. He disappeared along with 5 other friends. Recently, a pair of red jeans was found with bone fragments inside. One of the family members believed it belonged to their missing son and brother Jay Boyle. The jeans and belt are identical to the ones he wore the night he went missing. The families want DNA testing done to determine if it is indeed Jay Boyle or someone else. Jay's sister Amanda has sent around a petition to get DNA testing done. Police are denying this and have done their own investigation and report that says that other than the color of the jeans, there is very little else to match. Additionally, due to the location where they were found, some argue that they could not have traveled this far. Others argue that there are many explanations why the jeans were found where they were. Not only is DNA testing important for the family of Jay Boyle, but it could be important as it could identify another person who made a missing report about a family member in red jeans. It will bring closure to a family. The Missing People DNA Analysis and Identification of Human Remains article by an International Committee of Red Cross reports that the only relief for their families is receiving credible confirmation of the death, and that proper recovery and identification of human remains is a fundamental part of the healing process for families and even communities. DNA analysis allows for families to find out the fate of their family member, and also any remains can be returned to the family. So in this case, if these bones in fact belong to Jay Boyle, the family should be given them, and they can also give him a proper burial. These bones are considered the family's property. I chose this case as it deals with consent issues relating to the use of DNA. Consent was addressed in lecture, however not the specific issue, which is why I have decided to address it. With respect to consent, it was discussed in lecture that every patient has the right to bodily integrity and can decide on the procedures they want done to their body. In this case, Jay Boyle is dead, so he cannot make these decisions, but his substitute decision maker can. Therefore, if this is Jay's body and they want testing to be done, they should be provided with it. However, what if this isn't Jay's body? If this is someone else's body and the family of this person doesn't want DNA testing to be done and don't want to know what happened to their family member, then should DNA testing be denied? In many cases, the families are the ones that are actually objecting to the use of bodily substances. If testing was done and the family didn't consent to it, could this be considered battery, as batteries no consent at all? It is hard to determine the right action to take, as it is unknown who this body belongs to. The article Missing People DNA Analysis and Identification of Human Remains addresses the ethical and legal issues related to the use of DNA for the identification of human remains. The article reports information contained in a person's DNA is sensitive because it is a unique identifier and may contain information about a person's family and intimate associations. Therefore, it must be rigorously protected to ensure the right to privacy. Additionally, DNA testing can contain details about a person's pregenetic disposition to certain diseases. When I came across this, I considered what we learned about negligence and duty to warn of genetic risks. As it was discussed, Canadian courts have not really had the opportunity to discuss and determine whether or not there is a duty to warn family members of genetic risks. If they come across a genetic component that other family members have, should this be known, or should the DNA in this case remain only to identifying the body? It is difficult to determine. The family might want to know if Jay had any pregenetic disposition to certain diseases. However, they may not. Additionally, we were taught that duties to third parties must be balanced against privacy interests of the patient. Jay is dead, so we do not know if he would want this additional information disclosed or not. Is there a duty breached if the professional testing the DNA finds additional information about the body, however does not disclose this? This is a question I will leave open for you to discuss and determine. There There are bodies of law relating to confidentiality, privacy, non-discrimination, and human dignity that can be applied to the protection of genetic data. The article also reports that personal data may not be disclosed or transferred for the purposes other than those for which they were collected without the consent of the person concerned, except if required by substantial public interest or for the protection of the vital interests of the person concerned. In the case of Jay Boyle, the sole purpose is to identify if it is in fact him. If it is, this should only be known as it is not a public concern. It will only become a public concern if he was murdered, and that puts the public at risk. So to end this off, my last question is, do you think the remains that have been found should be tested to determine whose DNA it was? Why or why not?